Hey everybody, welcome to the Fulgham Law Firm. Welcome to our YouTube channel. Today I want to talk about a subject that's probably one of the most enjoyable things I get to do. Sometimes people tell me, you're a criminal lawyer. How fun is that? Well, one of the greatest things that I get to do is help people get things off of their criminal record. And so today I want to teach you how to clear your criminal record. But the first thing we have to identify is, do you qualify for it? Now, if you wait around to the end of this video, I will also share with you a free ebook, What to Do If You've Been Charged with a Crime in Texas. So let's jump right into it. Now, imagine this. Now, look, I know I'm kind of joking with you on this, but there's an old saying, I think it was Alexander Pope once said, to err is human, right? All of us make mistakes. Each and every one of us will do things that we look back on and we regret. Well, what if that mistake or that misjudgment leads in an arrest that now is on your record but could limit your ability to get a good job, could limit your ability to be able to maybe get a license, maybe you want to be get into real estate license, maybe you want to become a nurse or an attorney or a doctor. I mean, all of those things can be very negatively affected if you have a criminal record. So one of the things that we look at on this is if you have ever been arrested, charged, or convicted of a crime, please understand, here's the number one rule. Nothing ever automatically comes off your record. And I try to tell people this, they'll call me and say, yeah, but I was arrested and I was never even charged. Nothing bad really ever happened. I'm sure it's not out there anymore. And then I had a guy actually that called me one time. He had been wrongfully arrested of aggravated robbery 20 years ago and didn't do anything about it. They released him. He was never charged. And then he couldn't figure out why he couldn't get a good job for 20 years. And we found out, we were able to explain, well, wait a second. No, you got to get it expunged. You got to get it removed from your record, okay? So please, number one, nothing automatically gets removed from your record. So when we evaluate what we're looking at as far as your eligibility to get something off of your criminal record or to clear your criminal record, there's two main things we're looking at. Can you get your record sealed, number one, or can you get it expunged? Now, the two terms that we're going to identify in this video are non-disclosure and expunction, okay? I'm going to go into some of the specifics on this because a lot of people don't know the difference, and I think it's important that you know this, all right? So let's start off. I'm going to first identify the very first option is called a non-disclosure. It's what people think of as sealing your record is kind of the term. Now, in Texas, if you want to seal your criminal record, it must be done through this instrument called a non-disclosure. So now, what does that mean? What does it mean to non-disclose something? Well, a non-disclosure prohibits law enforcement or courts from disclosing your criminal record related to the order that you receive. So how does that benefit you? Well, in this situation, if you go and apply for a job, say a private job, and it turns out that that job runs your background check, they're not going to see it unless it's law enforcement or it requires a license of some sort, like a Texas Board of Nursing license, right? Or the State Bar of Texas for lawyers. They would be able to see that. But other private jobs, other private employment, they would never know about your criminal record, and you're allowed to actually deny it, okay? So that's the benefit there. Now, here's the thing. You say, well, that sounds great. That's probably what I would need. Well, let's identify what qualifies for an order of non-disclosure. It really only applies in certain situations and with only certain special crimes. So in order to be eligible, you must meet the following conditions. You can go research this, look up government code section 411.081, all right? I don't want to beat you down with a bunch of legal talk, but I do want to go over these with you because I think it's important. You got to follow each one of these steps. So number one, you must have been placed on a deferred adjudication, which means you were not considered to be convicted of the crime. Now you say, what's deferred adjudication? Go back to some of our videos that we're creating and continuing to put out every week, and we're going to have a video that talks about deferred adjudication, and I encourage you to look at that and we'll give you an explanation on it. But it basically means it's a type of probation that you're never found guilty, and upon completion of it, you can get your case is actually administratively dismissed. Okay, so number one, you must have been placed on deferred adjudication. Number two, you must have completed it successfully. Number three, your offense cannot have been, and I'm going to give you a list now, okay? Murder, capital murder, aggravated kidnapping, injury to a child or an elderly individual or a disabled individual, abandoning or endangering a child, stalking, or violating a court order on basically a violation of protective order in a family violence case, sexual assault or abuse, or an offense involving family violence. Very critical. Any offense involving a domestic violence is not eligible for a non-disclosure, okay? So you can't have any of these types of offenses I just read out to you on your criminal record in your past, even if you are not seeking a non-disclosure order for that particular offense. So if you have a previous domestic violence on your record and you pick up a new offense, you're not eligible, okay? You're not going to be eligible to get that done. So that's the next point. So that's number 4. Number 5, you have to wait the required amount of time, what we call the waiting period. The law spells out what the waiting period is. So what does that mean? Well, many times it can range anywhere between 2 to 5 years. Now, if it is a felony deferred adjudication, if you took a plea deal, let's do a hypothetical. Let's say it's a possession of a controlled substance, right? Drug charge, felony charge. And let's say possession of a controlled substance under 1 gram, you took a probation, a deferred, and you completed it. You've done everything perfect. You have to wait 5 years from the completion of that deferred probation, currently under Texas law, to be eligible for a non-disclosure, okay? 5-year waiting period on felonies, all right? There actually can be, and it used to be 10. It used to be a 10-year waiting period, and they bumped it down within the last decade. So that's number 1. Now, on most misdemeanors, it is a 2-year waiting period for most misdemeanors under Chapter 20, 21, 22, 25, 42, and 46 of the Texas Penal Code. That's a lot, okay? And that covers a lot of crimes. That's the vast majority of crimes involve a 2-year waiting period. However, there are some offenses you don't have to wait for, like shoplifting, some possession of marijuana under 2 ounces. There are some offenses that don't qualify for any waiting period, and you can do it immediately as soon as you finish your deferred adjudication. So notice it's kind of a little more complicated than it might appear, all right? Finally, you cannot have been convicted or placed on a deferred adjudication for any other crime from the date you started your probation till the date you finished your probation. So that means while you're on probation, you can't have gotten any more trouble. No more trouble, no picking up any new cases. Once you have to make sure you keep your nose clean during that entire period of time. If you don't, if you pick up something else, it's going to make you ineligible for a non-disclosure, all right? Now, let's talk about the next point, an expunction. That's the one that everyone really wants, is an expunction, because an expunction means that all the information and details pertaining to your arrest, your charge, or anything else related to your case is permanently removed, permanently destroyed from your criminal record. Literally, it creates a legal fiction. It no longer exists. So the gold standard is an expunction. If you can qualify for an expunction, you want to always push for that because it literally wipes your record clean, okay? Now, you could be eligible for an expunction if, and I'm going to give you a few ifs. 1, you were arrested for an offense but never charged. Number 2, you were facing criminal charges, but the case was ultimately dismissed. Number 3, you were convicted of certain qualifying lesser juvenile crimes. Number 4, you were convicted as a minor for certain alcohol offenses. And I know this is a little vague, but it's important. This is what the code says. You were convicted. Number 5, you were convicted for failure to attend school. You've got the next one, number 6. You were arrested, charged, or convicted. An arrest, charge, or conviction is on your record because of an identity theft. We have actually done this before. We had 2 people we represented. We had a guy we represented. Him and his brother were identical twins, and his twin claimed the contact information for his brother and was convicted. And anyway, point is, that was a disaster. If it was as a result of identity theft or someone just claimed your information, you qualify. If your conviction was later overturned by an appellate court, you would be eligible. And finally, if you received a pardon from the Texas governor or the United States president. So in addition to the above requirements that I'm giving you, you cannot seek an expunction. Listen to this. This is critical. You cannot seek an expunction if you receive deferred adjudication, or any probation at all. Class B misdemeanors and above, all the way into felonies, you cannot have taken any probation. If you did, you will not be eligible for an expunction. Also, you cannot seek an expunction if you were convicted of a felony within 5 years of the arrest you want expunged. And if the offense was part of a criminal episode or the statute of limitations for the felony charge hasn't expired. Now, what do I mean by that? Well, there is a waiting period as well for expunctions. This is the part that sometimes people don't, it seems unfair. For instance, we at the Fulgham law firm, we get a lot of criminal cases, felony cases, no-billed by the grand jury. Well, imagine, put yourself in this situation. You've been exonerated from your charge. A grand jury put a big stamp on a piece of paper saying you didn't do anything wrong. But under the law, many times you have to wait up to 3 years from the date of that no-bill of being cleared before you can get it expunged from your record. There are many other normally under Class B misdemeanors, Class B and Class A misdemeanors, you have to wait 2 years. And then on certain felony offenses, we have to look in to see what the statute of limitations is, which is usually in the 3-year range. There can be a longer period for more serious offenses. But you must wait the statute of limitations before you're eligible for it. Now, one caveat to that, all bets are off if it's a citation. If it's a Class C ticket, public intoxication, assault by contact, disorderly conduct, minor in consumption, these rules don't apply to that. You can be immediately eligible for certain Class C offenses if you take a deferred adjudication and you complete it, a deferred disposition, you could potentially be immediately eligible for an expunction. Or if your case is dismissed, you may not have to wait at all and you may immediately be eligible for an expunction as well. Now, I've given you a ton of information on this. My point is this. Clearing your criminal record is not as simple as many people want to make it out to be. You need to make sure you are working with a Texas attorney that knows the rules under Texas law to make sure you're going to be able to clear your record permanently. Now, here at the Fulgham Law Firm, we would be happy to answer your questions and assist you, especially if you have a situation like this out of the North Texas area. Feel free to give us a call at 817-877-3030, and we would be happy to help you. And thanks again for joining us today on our YouTube channel. Look forward to seeing you on our next video.